Hello, my name is Glenn Gaffney of Gaffney and Gaffney PC of Glendale Heights, Illinois, and my topic is, should your client sign that severance agreement? So when we talk about severance agreements, really the first order of business is to determine whether or not your client has any contractual rights. Is your client an employee at will, or does your client have an underlying agreement that you would need to review to determine what, if any, contractual rights your client may have? Let's assume it's an employee at will, there's no agreement. Now, the question is severance a gift? Is the company just being generous? Or are there things that you have to watch out for? What is the company getting in response to or in consideration for that severance? And that'll be the first area of inquiry, because really there's no law, rule, or regulation that requires any company to pay severance. So the company, what they're getting is a release and other terms and provisions that you will need to review with your client to determine whether or not they should or shouldn't sign it. So a written policy or procedure, maybe even a handbook provision, might create a contractual right to severance. If there is, then what obligation does your client have to sign anything in order to get that contractual right? Maybe, maybe not, but it would have to be reviewed. If there is no policy or procedure, some people say, well, what about precedent? They've paid other people severance. Courts have held precedent really doesn't work. Although an argument could be made that a failure to pay a certain type of person, whether older or female, things of that nature, could be a claim for discrimination. Now, in any severance agreement, there's going to be a release and waiver. And that is the most important thing to review with your client. What, in fact, are you releasing? You could be releasing any rights to a bonus. You could be releasing commissions. You could be releasing various claims, which would include discrimination claims, which would include contractual claims, which would include whistleblowing claims. What is the value of those claims? So a complete analysis would need to be made as to what, if any, claims your client may have. Because, for example, with commissions, the client may be subject to the procuring cause rule, which means a signature on a release and waiver would waive past, present, and future commissions. Same thing with other claims that might relate to overtime claims under the FLSA, vacation pay, things of that nature. So clearly, the release language would cover all those claims. So is your client getting fair value for whatever amount that's being proposed? If not, a demand letter should issue and suggest that the severance isn't sufficient, and we have claims here, and we need to negotiate those claims. Another area of concern typically is the area of restrictive covenants. Now, the first order of business is to determine what, if any, restrictive covenants are already out there, and how does this agreement play into that? Does this agreement incorporate other agreements by reference, or maybe this agreement would supersede any preceding agreements, which might be a good thing. Now, when we talk about restrictive covenants, one concern is always who is defined as the employer in the agreement itself, because oftentimes it's a broad-based definition. Would not only include the entity that your client believes he's working for, but also subsidiaries, affiliates, parental companies. That could be a very broad-based number of entities that now your client is signing an agreement that contains restrictive covenants that includes all of those companies. And when we talk about restrictive covenants, you have to keep in mind that you have to review that in terms of not only what the employer says is confidential or trade secrets, which really may not be confidential or trade secrets, but also things such as covenants not to solicit other employees, covenants not to solicit customers or even vendors, and most importantly, covenants not to compete. And how long is that covenant not to compete? Are you getting fair value in a severance agreement? So now your client cannot engage in his business or livelihood in a particular area. That may well not be worth it. And therefore, signing a severance agreement could have long-term implications, particularly as it relates to these restrictive covenants. Now, some other areas that typically lawyers need to review is the manner in which the severance is going to be paid. Is it lump sum, or are there payments over time? Typically, you would prefer a lump sum payment. However, payments over time could be beneficial if they also include COBRA payments, because your client is going to probably get a COBRA notice and have to pay COBRA insurance out of his own pocket, 102%. So if you can negotiate some COBRA payments in addition to the severance amount, particularly if there's payments over time as opposed to lump sum, that could be very beneficial to your client. Another concern is whether or not this agreement impacts any ERISA rights. We talk about ERISA meaning 401k, pension, insurance. The answer is typically no. ERISA has its own body of law, and these agreements typically does not impair your client's rights that are subject to ERISA benefits. However, violations by your employer of fiduciary duty in the past, or for example, if your client was terminated immediately preceding a large ERISA benefit, those types of claims can be waived because they're not subject to the law of trust that ERISA governs. And therefore, the consideration that your client is giving may include a waiver of those claims. Some other provisions that would likely be in a severance agreement is a no rehire provision. But why is that necessary? Why does your client precluded from not applying back to this company, particularly if the definition of the company encompasses other affiliates and other entities? A cooperation provision might be included. What about the expenses that your client incurs in cooperating with the company should your client be called upon to cooperate? And then there's usually a non-disparagement provision where the employer doesn't want your client to be making disparaging remarks on Glassdoor or in blogs or on the internet or on Facebook. Understandably so, but isn't your client also entitled to some degree of non-disparagement? At a minimum, your client needs to know what the reference will be to the extent that prospective employers of your client contacts this employer for a reference. So your client can rest assured that he has a contractual provision regarding references. Additionally, there might be a provision to the benefit of your client that they might afford your client some outplacement services. That could have value to your client, but your client may not want it or need it. So you might be able to negotiate a lump sum amount for the cost of the outplacement services in exchange for that right. You'll need to take a look at the remedies provisions as well. Be very careful of liquidated damages provisions. Some are so harsh that they'll claim that if your client breaches anything within the agreement whatsoever, your client has to refund all the money or some such other hefty liquidated damages provision. That would not be something that you would like your client to agree to. Also, remedies regarding attorney's fees. You're looking for neutrality here. If there's litigation arising out of an alleged breach, well, maybe the losing party should pay attorney's fees and not have it just be one-sided, so that if the employer claims and succeeds in having a finding that your client breached anything, that your client would be solely responsible for all attorney's fees. But if there's litigation and they lose, they should pay the attorney's fees. That's fair. What about venue? You want venue to be in your home court, not New Jersey or New York or some such other place. What law are we applying to this agreement? We want to apply Illinois law. That's our law. We know our law. We can research our law, and that's the law we want. Last but not least, you should always have a discussion with your client regarding taxes and the tax implications of this money. Severance money typically is taxed at the W-2 rate. It's like your client gets a large bonus from work. You can explain it that way. And if you think about it, that's a hefty tax. That type of money would be taxed probably, when it's all said and done, at a 40 to 45% rate by the time we figure federal tax, state tax, FICA, Social Security, Medicare. All of that, by the time you're done, rises to the level of about 42%. Now, maybe, just maybe, especially if you get into a negotiation game with the employer, you can have some of the money go to 1099, some of the money to be going to your fees and costs, and then only a balance subject to W-2 withholding. That would probably have better tax implications for your client, because at least some of the money would be subject to a 1099 miscellaneous box 3, and the ultimate tax liability, although it's still taxable income, could be more favorable. But always tell your client to consult with his own tax professional. Well, I hope this little video was of some help to you. I am a member of the Illinois State Bar Association Labor and Employment Law Section Council, and take a look at the website. You'll see the address here, and I invite you to become a member of our section and get our newsletters, which are numerous and sometimes lengthy, but I think you'll find they're very helpful, and we certainly invite you to make use of all the ISBA benefits available. Thank you.